Just a bit.
That's not it.
Eh?
That's not it.
Can't you put it on top of something so that I can? You understand? Okay, this is supposed to be all good now. Let me have those law reports, Minister idea. Put them on top of this place. I'll be making reference to them. Okay. So I can go on.
Yes.
Okay, I hope you're like this. I think I'm good like this. Oh, all right. Good day, gentlemen. So good to be with you once again. Today we are going to look at the assignment given to, I think that should be group 8, but I've looked around, I couldn't find any work submitted by group 8. But since the topic is, so we just go ahead, I just go ahead and teach you on the rule against hearsay evidence. So first of all, we want to find out the meaning of this word hearsay. Hearsay, I'll be needing this. Hearsay, maybe another one to support it. It might be the big one, bigger one. Okay. So we'll be looking at the meaning of the word hearsay. So before we even look at the legal meaning of that word, we'll first of all have to look at the simple, ordinary man's perspective of what this word means. Hearsay. Hearsay, just like the way it sounds. When you hear something, you say it to another person. When you hear something, which means somebody must have made a statement, somebody must have made an utterance which you heard, and you are now relaying it to another person. All right. So that can give us a little insight about what constitutes hearsay. But when we take about, in other words, hearsay simply means that statement that is not original to you. Is a statement that somebody made to you. Is a story, maybe a story that somebody has told you. Some facts that someone has narrated to you. So, which means when you are relaying this very statement to another person, another third party, you are not doing it as somebody who is making an original statement. No. You are somebody who is rather making a statement that you heard from a source. You heard it from a source and you are now relaying it to another person. So it's a different thing that you are the one, when you are the one telling the story, when you are the one who witnessed an incident, direct evidence, and then you are telling your audience, you're telling your friends, look, as I was passing through the post office, I saw a train, I saw this, I saw, because that's what you saw. Right. And remember that we also say that direct evidence also means evidence by somebody who saw, evidence by somebody who heard. But in this wise, that hearing now has limitation. I'm going to tell you what the limitation is all about. And that limitation will be more clear to us by the time we look at what the law means when the law talks about hearsay evidence. In other words, hearsay evidence in the eyes of the law is a statement, a restatement that is not original to this person who is now making the statement. It's a statement that he has heard from someone else. You know, in this part of the country, we talk about okreka. Okreka, you know, okreka means something that fairly used, has been used, and someone is selling it to you. So you may not even know who used the okreka cloth that you now want to put on, but all you know is that you are buying something. But the point to drive home there is that this okreka is not original. and you are not the first person who is wearing it. That's exactly how hearsay evidence operates. Now, what is the legal connotation of this word hearsay evidence? Hearsay evidence is a common law doctrine. It is a common law doctrine that has, in the course of time, been encapsulated into our legal jurisprudence statutorily. So when we talk about common law, like we know, those laws that did not originate from us, those the customs of England, those laws that we inherited from the colonial masters, and the locus classicus for this word known as hearsay is the decision in the case of Subramania against public prosecutor. Subramania against public prosecutor. I'm just going to paraphrase the decision in that very case. Now, the decision in that very case has two arms, two ambits. The first ambit of it simply states that a statement made by somebody who himself is not the originator of that very statement is hearsay and inadmissible in law. Let me put it in another way as I'm paraphrasing it. Hearsay evidence by the decision of the case that I have cited simply means a restatement of a statement made by someone else who himself is not called to come and testify as a witness in the court. Now, that statement is hearsay. And the second arm of it tells us the legal implications of this hearsay. Hearsay evidence is inadmissible if the purport, the reason, the basis of restating that statement made by someone who has not been called as a witness, if the purpose is to establish the truth of that very statement, then it is inadmissible. Of course, it is purely commonsensical because you were not there. The person simply told you something, and you heard what the person told you, and you are now recasting that very statement to another audience. You are restating it to other people. If the purpose why you are making that statement or restatement is simply to show that Mr. A made such statement, then even though it is hearsay, the law prohibits inadmissibility of hearsay evidence will not prohibit that one. In other words, it is said not to be hearsay and admissible. Get it right. In other words, from the beginning, that word, that statement that Mr. John told you that Mr. A has bought a car and that he bought that car with stolen money, and then you have gone to your community or you have gone to another person and you say, can we imagine that Mr. John used stole our money and used it to buy a car? Some of the times you won't even quote the person who told you. Now, assuming you quote the person who told you, it's a mere hearsay, and it will be admissible if the essence is just to say that he mentioned this thing to me, he said this thing to me. But whether it is true or not, I don't know. Then it becomes admissible hearsay. But it is hearsay and inadmissible where your reason, your purpose of making that statement all over again is to establish that it is true, that it actually happened. Then the law will tell you that it will not be admitted in law, it will not be admissible. Why? Because you are trying to assert the truth of a statement made by somebody who has not been called to testify, and that statement is not an original statement to you. So that is what Subramania case talks about when it comes to what constitutes hearsay evidence. Then let's look at our own law. Section 37 of the Evidence Act. Section 37 of the Evidence Act states, and I'll just read and then also explain. Hearsay means a statement. That's what the provision is saying. Hearsay means a statement. It has divided it into two now. A, oral or written, made otherwise than by a witness in a proceeding. In other words, before you begin to categorize whether it is an admissible hearsay or inadmissible hearsay, Section 37A has simply told you that that very statement made by someone else who is not a witness in a matter is what is hearsay. It doesn't matter whether the person made that statement orally or in writing. So long as it is made by someone else and that person is not coming to court to give evidence as a witness. So the first arm has covered it as what hearsay evidence. Then what does B say? 37B says, or contained or recorded in a book, document, or any record whatever, proof of which is not admissible under any provision of this act, which is tendered in evidence for the purpose of proving the truth of the matter. Is it telling us another genai of hearsay evidence, another class of hearsay evidence? Remember, A says it can be oral, it can be in writing. B now is saying it can also be contained in a textbook. It can also be recorded in a document. I remember that when we talk about document within the purview of the Evidence Act 2011, we also include electronically generated evidence. In other words, that text message you sent to your friend in your phone is what is a document, is stored in your device. That device is what? The phone. And the phone also qualifies as what? As computer. So what this provision has done is to elaborate even the decision in the case of Subramania against public prosecutor. And it is telling us here that once the maker is not the person who is giving the evidence either orally or in writing or bringing that book, bringing that document, bringing that device where it is stored, that it becomes what? Inadmissible. It becomes an inadmissible hearsay evidence, especially if the tendency is to establish the truth. This is where it has borrowed the second arm of the decision in Subramania's case. And at times we begin to wonder if somebody comes to court, the person wants to prove his case, and he brings maybe a document made by the cause rep, who himself has not been called as a witness to give evidence in a matter, and tenders. This letter, this document is from the cause rep. It is an account of what happened, and this document will show that Mr. A did this, Mr. A did that. It becomes what? An inadmissible hearsay evidence. If you want, why? Because as you want the court to look at that document and believe in the content, you are trying to do what? Establish the truth. Therefore, in almost every hearsay statement, either oral or documentary, 80% of the intention is to establish the truth, no matter what you think about it. 80% of it is to establish the truth. If not, all you simply will do is to do what? Subpoena the person who made the statement. If you feel you cannot easily bring him to court, you can subpoena him. But when you want to go ahead to rely on the statement he has made, no matter how he has made that statement, the the underlying ulterior motive there will be to help you prove your case. And what does that tell you? You simply want to establish that what that person said is the truth. You want to establish the truth of the contents of that statement made by somebody who is not even called as a witness. Therefore, it becomes what? Hearsay and inadmissible. Hearsay is like an opposite of direct evidence. Hearsay evidence is opposite of direct evidence. I want to look at some statutory authorities so that we can also understand how the Nigerian courts have followed this decision. The first one I want to talk about here now is the case of, can I have, sorry, can get me part 1893, part 1893 and 1888, 1893 and 1880. Okay, I've got 1888. Give me 1893. So, in this very case here now is the case of Nenna Aladum. Nenna Aladum against Obu. Nenna Aladum against Obu. For this one, open page 489. 489. Nenna Aladum against Chris Obu is reported 2023. Reported 2023. 9 Nigerian Criminal Law Reports, part 1888, page 57. So I want to read what the court said, what the Supreme Court stated about hearsay evidence. The first ratio here goes like this. Scope. Scope of the rule of hearsay evidence. Assertions of persons other than the witness who is testifying, including statements relied on as equivalent to assertions, although not primarily intended as such by their maker, and conduct relied on as conduct equivalent to the actor's assertions of any fact other than his contemporaneous state of mind of physical sensation, although not so intended by him, are inadmissible as evidence of the truth of that which he asserts. So when you look at the decision, why I pointed out at this decision is that the Supreme Court has also added or extended the scope or provision of Section 37 by talking about conduct. So you cannot want to show conduct which actually was someone else's conduct with the hope of the court believing you that this conduct you're portraying now is actually the truth, the true conduct of Mr. B, who you have not called to testify for you as a witness. And one other lesson we can garner from the Supreme Court decision here is that a good number of times, maybe the person who is relying on hearsay evidence may not himself be able to differentiate whether the law talks about establishing the truth of the hearsay or not establishing the truth of the hearsay. Mind you that a good number of the witnesses you're bringing to court are not even lawyers. They didn't read law. So that's what the Supreme Court is saying here, that the ultimate test is for the court in evaluating this very hearsay evidence to find out whether this witness who is testifying is trying to establish the truth of a statement made by another person who has not been called, or the conduct of another person who has not been called, or a write up of another person who has not been called as a witness. So once the court has that behind its mind and the court is satisfied that the essence of this person said this thing is simply to say that I believe that this is what the man said, that becomes hearsay and inadmissible in evidence. So the Supreme Court also in this case did a list of some exceptions which I will look at much later in the course of the proceeding. Then let's also look at yet another case, the case of Onyeka Ilo Uno. Onyeka Ilo Uno against the state. Onyeka Ilo Uno against the state is also reported in 2023 10 Nigerian Weekly Law Report, part 1893, page 489. Page 489. So we want to look at what the Supreme Court has in the main said concerning the issue of direct evidence, which I said is the opposite of hearsay evidence. Here, the court talked about effect where direct evidence links person with commission of crime. As Supreme Court says here, where there is direct evidence linking an accused person with the commission of the offense, he can safely be convicted for the commission of the offense. He can safely be convicted on the commission of the offense. In the course of this work, I will also tell you why I have cited this very case so that it is not an issue of maybe the police that investigated the matter trying to rely on evidence that have not been brought before the court. So when you read the facts of this case, you're going to begin to see the major difference between direct evidence and hearsay evidence. Just suffice it for you to know that hearsay evidence is what second-hand information or critical information, just like we just jokingly refer to it. So we have been able to explain the first arms of the first and second arms of the rule in Subramania case, as well as we looked at section 37 of the Evidence Act, and in support of that section 37, we also want to look at section 38 of the Evidence Act. And it says, hearsay evidence is not admissible. That is stating the general rule. Hearsay evidence is not admissible except as provided in this part or by or under any provision of this or any other act. So, irrespective of the fact that Section 37 has told us if you want to relay an information given to you by another person who is not coming to testify, and you want to show that what that person told you is the truth, that becomes hearsay and inadmissible. But look at section 38. It's telling us that there are some situations where that rule is relaxed. So that is where we are going to do an excruciating X-ray. If you've already told us that I cannot rely on a statement made to me by a person who is not called as a witness, why would you have exceptions to that very rule? So when we come to these exceptions, we brainstorm on it and know why the law has thought it wise to relax the rule in some certain circumstances. So the next thing arising from what we have discussed so far, we want to talk about the types of hearsay evidence. Remember that Section 37 has already guided us. It has told us it can be oral, it can be in writing, it can be stored in any book. In other words, let's sum it up. What is a summary? When we talk about types of hearsay evidence, the first type of hearsay evidence is oral evidence. Oral hearsay evidence. Most of the times that one that goes like gossip. Um, Nkiru told Ngozi to tell Nkechi, to tell Rose, to tell Caroline, who later told me that. So you discover this is all wrapped up in hearsay evidence that are oral in nature. So long as that originator of that statement is not called to say what actually happened. That could be changed, just like I've said, chains of dissemination of hearsay evidence. A has told B, B told C, C told R, R told X told Y, Z, and until it gets to you, except the root, the first person who witnessed the incident, who is the originator of that statement, is called to testify. That entire thing becomes what? Oral hearsay evidence. So see the case of Ojo against Haroro. Ojo against Haroro. Haroro is spelled Gharoro. It's reported 2006 of Federation Weekly Law Report, Part 316, Part 197. 197. So I can also give us yet another case on oral hearsay evidence. Okay, so that's the case of Yahaya. Yahaya against FRN. Yahaya against FRN. Yahaya against FRN is reported 2022, 8 Nigerian Weekly Law Report, Part 1831, page 109, and it's another Supreme Court decision on the issue of hearsay evidence. Now, how the Supreme Court put it here is simply this way. I'm going to read about two rationales for us to follow the reasoning of the Supreme Court. The first one is a court of law can only use evidence that was tendered or put before it. A court of law can only use evidence that was tendered or put before it. And it says, in this instant case, the court could not make use of the extrajudicial statement which was not in evidence before it. Read this case. It's very important. The facts of this case will guide you to understand more what I'm talking about. And then, still in the same case, the Supreme Court said, yes, evidence is inadmissible in law. That is a kind of general statement. Why that general statement? Is because, like I said, most people who are relying on hearsay evidence simply wants to establish the truth, either consciously or unconsciously. That's why the general rule is like this, that hearsay evidence is inadmissible in law. The evidence of a statement made to a witness by a person who is not called as a witness is hearsay if its object is to establish the truth of what is contained in the statement. If its object is to establish the truth. Now, the witness may not even come to tell you that, my Lord, why I'm saying this is because I'm believing that what I'm saying that Mr. B said is truth. He may not even say that. So that if is within the anchor of the discretion of the court, or let me say the activism of the court, to look at the evidence holistically and to find out what actually is the intention of this person. Now, the intention of that witness to establish the truth may also come out during cross examination. The person has said, OT told me that this is blah, blah, blah. Maybe while cross examining, the counsel on the other side may, simply ask him, okay, you have told the court what OT said because you believe that OT said the truth. And he tells you yes. Once he says that, it becomes obvious that his intention is to do what? To establish the truth of that statement made. Then the Supreme Court also went ahead to say, but where, besides the hearsay evidence, there is strong admissible evidence to establish a case which is admitted, the admission of the said hearsay evidence could not have caused a miscarriage of justice because without it, the decision of the court will still be the same. I will explain what the Supreme Court is saying here. The Supreme Court is simply saying the fact of all the evidence being given by that witness, you have to apply that law of severance. Right. Severe the evidence that is within his information, that within his personal knowledge, from that one that is hearsay evidence. So that if you do that, you may discover that in the end, when you have already, if the court had already removed the hearsay evidence, the court can still rely on the evidence of this person who has done what? Who has testified. Despite the fact that part of his evidence constituted what? Hearsay evidence. This is possible where his evidence are pieces of different evidence, pieces or species of evidence. So those ones that will be useful to court that are admissible, the court cannot say because part of this evidence given by this man is hearsay evidence, therefore everything is tainted. No, it's not a case of one bad apple spoiling the whole lot of bunch. No, that is not exactly how it works out. Now, we have talked about that, and I also want to give us some examples of oral hearsay evidence. Just as Supreme Court has given us one, and I have enjoined you to read it. And the second one is where maybe an IPO, the investigating police officer, while giving evidence, tries to give evidence of what somebody who was also arrested or what a witness in that very case told him, when in fact that witness has not been brought to court. So if the IPO tries to do that, the evidence of the IPO will be regarded as what? Oral hearsay evidence, and what? Inadmissible. Because the IPO coming to court to give evidence is actually not coming to court to play. He's coming to give an evidence which he feels will help the prosecution to establish his case beyond reasonable doubt. In other words, so his business is to come to court to give evidence of truth of the fact in issue. Ask him to wait. I will see him later. If he can wait. All right. So that is another example, of oral hearsay evidence. You can also have yet another example of oral hearsay evidence where, for instance, at the police station, the suspect could not speak English, or he is such a person that neither speaks nor understands English language, and then at the police station